He used to be appointed as the Commissioner for Victoria and was the leading character for building up Australian-China relationships since 2009. He single-handedly facilitated an increase by over 300% for Victoria's inbound investment from China and was directly responsible for assisting with over $400 million of direct investment to Victoria. However, in his wildest dream, he might never have imagined that one day he would be sued by both Chinese investors and Victoria's state government, not for his political stance or strategic planning, but for attendance of some social events in Shanghai back in 2013 and a change of Australian visa. For years, Australia quietly operated one of the world's most controversial golden visa programs, the Significant Investor Visa. Supporters called it as the smart migration policy that facilitates economic growth and global investment. Critics criticized it as a money laundering channel, creating a loophole for the ultra-rich and a backdoor into Australia. And after years of controversy, Australia killed it, but the aftermath is continuing. Lots of investors suffered from loss of their investments. Financial institutions were under investigations. Brokers and agents ran away, leaving liquidators and receivers chasing for money that disappeared. Imagine you are a wealthy overseas investor. A few years ago, you wanted to migrate to Australia. The government told you that you could invest millions into the Australian market, support the economy, and obtain residency through a fast track. Sounds prestigious, safe, because it's government-backed. Then one day, you got your visa but heard your money was gone. You started asking the question, why misled by people connected to the government? And should the state government be responsible for my loss? That is the explosive background behind Lou and Gong case. This case involves Chinese investors, Victorian government officials, and the collapse of a Dubai-based financial empire. But this case is bigger than just one failed investment. It raises uncomfortable questions about cross-border enforcement. Why suing a person living in China is so difficult, and where do we draw the line between economic development and selling access to residency? Let's start with the background of the controversial topic, Significant Investor Visa. What if residency itself become an investment product? The Significant Investor Visa, often called the Golden Visa, was introduced in 2012 under the Julia Gillard government. No English test, no skills required, no need to build a business here. Just invest $5 million and you can buy your way into Australia. The idea sounded simple. Such type of visa would attract overseas capital, stimulate the economy, and create jobs and business investment opportunities. At the time, many countries such as Canada, UK, Portugal, and Cyprus were doing similar things. Everyone wanted wealthy migrants and their money. Very quickly, Chinese applicants dominate the program. By 2023, over 20,000 Chinese nationals have received these visas, representing the overwhelming majority of the approvals. But here's the twist. The government itself kept changing the rules because people found loopholes. Initially, investors could place money into relatively passive investments, including government bonds, managed funds, and low-risk financial products. Then criticism quickly emerged, arguing that wealthy applicants were parking money passively without delivering real economic benefit. The government later forced investors into venture capital, private equity, and those emerging companies. The goal is to push money into innovation-focused sectors. But another problem emerged. Many investors weren't really entrepreneurs. They invested due to needs of assets diversification, kids' education, or simply residency insurance in a Plan B country. Then various scandals were exposed. In 2023, ABC reported that Australia's golden visa system had granted over 26,000 visas. Rejections were extremely low, and financial crime experts feared the system attracted dirty money. Austrac also expressed concerns and reportedly warned of difficulties verifying sources of funds for wealthy offshore applicants. The second contested issue is that by funneling overseas capital into assets, the scheme would eventually increase pressure on Australian property markets and housing affordability. There is also politically sensitive concern. Critics argue that the system would unduly increase foreign influence, as the scheme operated like a luxury membership program or elite network. Productivity Commission heavily criticized the program as they consider skilled migrants contributed more economic value than investor visa holders. There is also debate that residency is right and should not be purchasable, and even if it is purchasable, Australia is selling visa too cheaply. So after more than a decade, Australia finally pulled the plug. In 2024, the Albanese government abolished the Business Innovation and Investment Program, including the Significant Investor Visa stream. The plaintiffs in this case are beneficiaries of the Significant Investor Visa, but are also the victims. The plaintiffs, namely Song Lu and 𝗷cie𝗶ဖိ, were Chinese citizens who wanted significant investor visas. Each of them invested sums totaling $7 million. They appointed a person named 𝗷cie𝗶ဖိ, also known as Kate, to act as their migration and investment agent in China in September 2013. At the time of this video, the hearing hasn't been concluded, so we can only describe the facts known to the court from the plaintiff's perspective. On 20 September 2013, Kate attended an event held by the state of Victoria in Shanghai, China. Also in the attendance were the then Premier of Victoria, 𝗷cie𝗶ဖိ, Patrick Stringer, who in 2013 and 2014 was the Commissioner of Trade and Investment for Greater China and Mongolia, 𝗷cie𝗶ဖိ, who in 2013 and 2014 was a significant investment manager in Greater China, and 𝗷cie Mustafa Safi, who was the sole director of Paragon Business Group. Paragon carried on a mortgage broking business and provided lending services to customers. Paragon's business also involved promoting a deposit lending product as a compliant investment for the purpose of the Significant Investor Visa. According to the plaintiffs, during the event, Patrick and Jessie told Kate that Victoria state government recommended and endorsed Paragon's deposit lending product. On 26 May 2014, Patrick and Jessie repeated the statement to Kate that the product was a safe investment, offering capital guarantee with fixed returns. It then turned out that Jessie received financial benefits for promoting Paragon's lending product. Neither Jessie nor Patrick disclosed this to Kate. On 11 August 2014, Kate lodged the visa applications on behalf of the two significant investors. The applications nominated Victoria government bonds as the compliant investments. In August 2015, relying on the statements by Patrick and Jessie, the investments were switched from government bonds to Paragon's deposit lending products. Under the investment application form, each investor's money would be repayable within 4 years. In September 2015, significant investor visas were issued by the Australian government to the plaintiff investors, but they have never been repaid with their $7 million investment in accordance with the contractual terms. Then the investment scheme failed. On 23 August 2019, Paragon was wound up and had liquidators appointed. Freezing orders were also made against 𝗷cie personally in early 2026. The empire of Paragon was ended. The plaintiff's case was that by making the representations, each of Jessie, Patrick, and Victoria state government engaged in misleading and deceptive conduct or made false or misleading representations in contravention of Section 18 and 29 of the Australian Consumer Law and similar provisions and ASIC Act. They sought compensation against all the defendants. The state then brought a cross-claim against Jessie, Patrick, and Kate seeking contribution or indemnity, but the problems arise when legal documents can hardly be served on cross-defendants. Patrick and Jessie eventually accepted service, but Kate was nowhere to be found. This judgment was not the final trial. It was about something more technical: service of court documents in China against Kate, who is the investor's advisor and is a Chinese citizen. The state joined Kate in the proceedings for two obvious reasons. Number one, Kate was alleged to be negligent in advising the investors about the visa requirements and risks involved. And second, since Kate would likely to be a key witness for the plaintiffs, because Jessie and Patrick's statements were made directly to her. Bringing Kate as a cross-defendant will keep pressure high against the plaintiff's side. A tactical move, from our opinion. The state initially could not find Kate, but managed to obtain Kate's email address, a mobile number, and her living address in China. On 29 April 2016, the state's lawyer, Mr. Allison, sent the legal documents to Kate's email address without any reply. When telephone call was made to Kate's mobile, she answered the call but said, "I don't know you or what this is about," and immediately hung up. On 6 May 2026, the state engaged a Chinese law firm named Shanghai Rewing to serve the documents to her Chinese address in Shanghai. However, when the documentation was delivered, Kate was not there. A man who identified himself as Kate's father accepted the documents. The father confirmed Kate's mobile number but denied that Kate was living with him. The law firm Shanghai Rewing also sent a follow-up text message to Kate's mobile number stating that the legal documents were left with her father, but Kate never replied. Australia and China are both parties to the Service Convention. Normally, court documents must be formally served internationally. There are established principles about service of originating process outside of Australia, and by substantial amendments from 13th January 2023, a party is no longer required to seek leave before service as per federal court rules. The service does not even need to be in person as long as it is served in accordance with the law of that country. Although leave is not required, under Rule 10.43b, the person who is to be served outside Australia with an original application must still be served with a notice in accordance with certain formal requirements, informing the person of the scope of the court's jurisdiction, and this is known as Form 26A. But the problem is that in order to comply with Hague Convention, the service process in China can take around 6 months, because one needs to apply for a request with the China's nominated central authority, namely the International Legal Cooperation Center. This will further delay the proceeding, especially when it's clear that Kate is trying to avoid being served. The state therefore has applied for an order of deemed service and the court rules. Under Rule 10.48, a party may apply for an order that a document is taken to have been served if it is not practicable to serve the document on the person outside Australia in accordance with the Hague Convention, and that document has been brought to the attention of that person. It's clear that the state has taken adequate efforts to bring this matter to the attention of Kate. The father of Kate even confirmed that he would give the documents to his daughter, and telephone or text message communication had been made with the same effect. But to prove it's not practicable to serve documents in compliance with Hague Convention is more difficult, because the state did not attempt to serve documents to Kate in accordance with laws in China. Rather, it attempts to serve the documents to Kate in person, and that attempt was unsuccessful. The state provided evidence that the time for execution of a request and the Hague Convention by the China's International Legal Cooperation Center was around 6 months. The state then argued that this delayed would render service become not practicable. Justice O'Brien said that was too simplistic. The phrase "not practicable" does not mean it is inconvenient to serve. Something more than inconvenience or excessive delay is needed. But the judge also noted that since the state could not identify the address of Kate, it may well be the case that it was not practicable to serve the documents. Importantly, the judge said the question of practicability involves a balance between two competing considerations. Firstly, there are considerations of international comity and importance of personal service. Secondly, there are considerations of efficiency and practicality in the conduct of these proceedings. After balancing these factors, the court eventually was convinced that even if the state followed Chinese laws, the service 6 months later might still be unsuccessful, and therefore orders should be made that the documents were taken to have been served on Kate. The court essentially said, "We cannot let international procedural delays freeze the entire case forever." Kate is now joined as a party to these proceedings and had to answer the claims by the state of Victoria. We will continue to follow the case's development and what final judgment is about, unless it's settled outside of the court. This case may affect Australia far beyond migration law. Firstly, cases like this affect global trust in Australia's migration investment systems. This is not the first time migration and investment schemes collided disastrously. Australia has previously seen non-compliant migration-linked property schemes, fraudulent investment migration products, misuse of investor visas, and unlicensed financial promotion. We had to ask whether this is worthwhile, where both investors and sponsoring governments were exposed to huge risks. Second, Even informal government association can create perceived legitimacy. Imagine attending a government trade expo overseas. You see officials standing next to an investment promoter. Naturally, many people would think this must be trustworthy. That is why this case is potentially explosive. That creates legal and political risks. In this case, for an example, both Kate and Patrick are the middleman. Kate acted for investors, while Patrick acted for the state. Without the court proceedings, people won't know what had been said between them. Any representations or transactions involving multi-million-dollar investment backed by the government's nomination could be out of control and cultivate corruption. When the investment fails, agency laws kick in, everybody gets sued, and nobody is safe. Thirdly, this case shows how hard it can be to sue overseas parties, serve documents internationally, and enforce rights across jurisdictions. This is typically difficult when the counterparty is in non-common law countries like China. Since 2024, Australia has moved toward prioritizing skilled workers, labor shortages, and active economic participation instead of passive wealth migration. But even after the significant investment visa has been abolished, some politicians still discuss bringing it back because wealthy migrants still offer capital inflow, business networks, and tax revenue. Countries still compete for global wealth, especially during economic uncertainty. Even if the investment channel will be brought back, future reforms are inevitable, including much stricter source of funds tracing, national security and anti-money laundering scrutiny, and limitation of investment in sectors such as technology, clean energy, and advanced manufacturing. The focus will be on bringing value rather than bringing money. Now let me leave you with this. Should wealthy migration schemes even exist at all? Or was abolishing the significant investor visa a mistake that may cost Australia competitiveness in global stage? And if government representatives attend investment events, what roles should they play? Please let me know your thoughts, and don't forget to like, subscribe, and follow for more Australian legal analysis and major court cases. Thanks for watching. See you next time.